So the jury coming back after just about 3 hours of deliberations, coming back with what was very little surprise for those of us who watched the case. Now, still with us is Court TV legal correspondent Chanley Painter, and joining us now, trial attorney and former prosecutor Leslie Ricard Chambers. Thank you both, Chanley, for staying with us and for joining us as well, Leslie. So I want to start with you, Chanley. You know, one of the things I kept thinking as I'm watching the case, over and over, I'm looking at the evidence. I say, a little part of me thinks that maybe he wanted to get caught. Is that possible?
It is certainly possible, and I've read through the court file, and I've listened to a lot of the reporting on this case over the years. There was actually a suppression hearing in 2019 where Joel Guy Jr. took the witness stand, and he talked about a lot about himself and this crime, and at that point his testimony was to the judge that he actually left the crime scene because he almost sliced his thumb off. We've seen throughout testimony that deep cut in his thumb that was bandaged up at Walmart on that surveillance video the prosecution kept pointing to. And he told the court during the suppression hearing that he was afraid he was going to lose his thumb. So he left in a hurry to go back to Baton Rouge for whatever reason to go to that medical clinic. There's records from that medical clinic that if he took the witness stand, the prosecution was going to use, because he told the medical clinic that he hurt his hands going down some stairs with some breakables. And so it seems as though he wasn't complete. He wasn't done with this crime scene. There was a lot left on that book of premeditation to-do list for him to complete before the crime scene was over. So if not for the injuries to his hands, he may have had some more time to complete this, and then the authorities wouldn't have found the crime scene in the state that it was, with a plethora of evidence, physical evidence for them to test and go forward. And it also, just to your point, closer to the trial, Michael, it seems as though, because he did make a handwritten motion to try to ask for the death penalty, you're not sure exactly what that indicates, but maybe he knew that he was likely to be convicted, and maybe he wanted to have a little more control over his fate.
Yeah, it's possible that the panic of the cut led him to leave his backpack in the house, so that's definitely up for debate, but great information, Chanley. Thank you. Leslie, let me bring you into the conversation now. At some point, I'm going to ask you to wear both hats, both as a former prosecutor and a defense attorney, but right now I want to start off as a prosecutor. You're presented with a case like this, a plethora of evidence, more evidence than you probably have ever had before. Are there any pitfalls to watch out for? Because I can't imagine that it's so easy, or as easy as it looks, when you have so much evidence, and not all of it is very nice.
Thank you for asking that. I think that Chanley just brought up a good point, that in these suppression hearings, you want to make sure that your evidence is sort of top-notch, I guess, on the front end. You want to make sure that the collection of the evidence is not compromised. You want to make sure that the evidence, the integrity of it is not compromised. And so it seems to me as if the state was able to already overcome that. And at this point in a trial, probably one of the only things that could possibly make things go a little left is if witnesses are unavailable, police officers, initial responders, folks who can sort of create that chain of custody scenario and create this visual for the jury. When you've got someone whose position in this trial is to create this scenario for the jury to follow, then maybe the state could have had some potential issues, but it doesn't seem as if they had that here. It looks like everything flowed very smoothly, and just based on the arguments from the state that I've heard so far, it sounds like that they were really able to create a point A to point B all the way through all the letters of the alphabet, if you will, to let this jury see exactly what happened, how it happened, and even why it happened.
You know, it's interesting that you mentioned chain of custody, because one of the areas where the defense decided to try to poke some holes in this mountain of evidence was regarding chain of custody, regarding the testing of DNA evidence, things of that nature, to try to create a small bit of doubt. I want to get you to put on your defense hat now and say, again, you're presented with this case, with this particular defendant. How do you go about approaching a defense here?
Well, what I would present is that, maybe they have something, but the DNA doesn't belong to him, and somehow figure out a way to say that the DNA or the lack thereof is insufficient. If there is DNA, then why was it present in some parts of the evidence, but not in these other relevant parts of the evidence? And so if I'm the defense attorney, I'm questioning whether or not the strength of the DNA has true veracity, I guess. And if it doesn't, then that might be something that could be a challenge for the state.
Yeah, as I watched the defense work here, and they were certainly wonderful attorneys and very seasoned attorneys, I was wondering if there were some opportunities there to do a little more objecting to some of the cross-examination, of some of the direct examination by prosecution of their witnesses, where they were asking questions where perhaps the particular witness didn't have expertise. And if you're going for a reasonable doubt case, and that's the approach you're taking, you want to keep trying to let the jury know that, hey, the prosecution is overstepping their bounds here. They're doing some things wrong here. And that would help you in the end say, hey, there's some reasonable doubt here. Were you surprised there wasn't more opportunities or more chances for the defense to jump up and maybe make a little more ruckus in the courtroom?
Well, you definitely want to, at least as a strategic measure, you want to object as much as you can, right? So that, when the state is on a roll and they're connecting with the jurors and they're connecting with their witnesses and inadvertently having the witnesses really connect with the jurors, you want to be able to stop that, right? Because if you don't, then it's just going to be a train wreck for your case and for your client, regardless of how stacked the evidence is against your client. You want to be able to put some interruption in that. And whether your objection is really based on something solid, you want to be able to also make that objection for any appellate purposes. If you don't raise an objection in trial, you certainly can't raise it in an appeal.
Well, they were certainly preserving the record very, very well. All right, Leslie Ricard Chambers, please stand by. Chanley, stand by as well. We're going to take a quick break. And when we come back, Joe Guy Jr. is guilty on all 7 counts of killing his parents. And we'll take a deep dive on the motive in this case just ahead. Stay with us. Hello and welcome back to Court TV. I'm Michael Ayala. The verdict today for Joe Michael Guy Jr. is guilty on all 7 counts. He was found guilty of killing and dismembering his parents, and the state took jurors through the often gruesome elements of the case. And we're going to be trying to show you a little bit now how they proved guilt. And we're going to begin to take a look at motive. And first, let me bring back in Leslie Ricard Chambers. She's a former prosecutor and a trial attorney. And before we begin to look at some tape on the case, I want to get your impression as to how important motive is. In this case, it was handed to the prosecution on a silver platter. It was written down. It was right there. And oftentimes, motive is the hardest thing to prove in these types of cases, especially in patricide.
I agree. I'll tell you, here in Louisiana, in second-degree or first-degree murder cases, we don't have to prove motive here. In this case, it was really well established why he killed his parents, and the fact that, he wrote about it. So as to journal about it, it seems to me as if the state really had an advantage with his words being on paper, particularly when he appeared so stoic in these processes of this trial and as well as the pretrial hearings, if you will. It really helped set the tone for the state to say not only did he do it, but guess what? If you don't believe that he did it, because no one wants to believe that someone will kill their parents, especially in this manner, here is why. And so in this scenario, the state really had an advantage here of really being able to nail down exactly why he did what he did.
It's fascinating. You said you don't have to prove motive in Louisiana. Let me ask you, as a trial attorney, don't you think jurors want that? Even though you don't have to prove it, isn't it really good for your case to be able to say this is why a person did what they did?
Absolutely. And it's our natural human instinct to know why someone does something or doesn't does something, right? And as many trials as I've tried, especially homicides, that is the question that all jurors come up with. They even though we in voir dire tell them, look, here in Louisiana, you don't have to prove motive. We only have to prove to you that this person had the intent to kill the person that is deceased, and naturally people want to know why. So I don't think that there's an issue there, but it definitely does give jurors some sort of solace, I guess, when they are the deliberators of a person's fate, because even though the judge is responsible for issuing the sentence, if you are convicted by a jury of a crime of murder such as Joel Guy, then I think that, you kind of know what the exposure is in terms of sentencing.
Yeah, I want to get into a little bit more of the jury dynamics in a second. But first, I want to play a piece of tape of Robin White. She was the sister of one of the victims in the case, and she's going to give us a little sense of where the prosecution was going in terms of what Joe Guy Jr.'s motive was. Let's take a listen.
My brother had stated to me that he was retiring and moving up, and he had cut his son off from any money, anything. He was tired of keeping him up. And Lisa was fixing to move in the family home, and Lisa was fixing to cut him off when come Christmas when he was supposed to come in. But he came in for Thanksgiving instead.
So there you have it. I mean, Joe Guy Jr. was about to find out, or had found out, that the family was going to cut off all the money they had been sending him to basically support him for the 32 years of his life, and he wanted to get his hands on some insurance money. But I want to get into a little bit of the jury dynamics. I heard you say you speak to jurors. When jurors go into that jury room, I believe that they take their job extremely seriously. What are some of the things that in a case like this you think they're focused on? It took them 3 hours, which surprised a lot of us here, surprised a lot of our viewers as well. What is the first thing that happens in that jury room? What is that dynamic like?
Well, I think that what people don't realize in a case like this is the weight of the information. And I'm looking at the circumstances surrounding the victim's death, and that's a really heavy set of facts to take home with you, right? And so I think that at least for those first several minutes, when they go back into the deliberation room, they've got to be able to process all of these horrible facts and circumstances that they've had to hear all week long. And let me just say this too, because I know that I know firsthand that Joel was in Baton Rouge before he was extradited. He was actually in my courtroom here in Baton Rouge and was extradited to Tennessee right after these murders happened. And I can tell you that looking at him sitting in the box with the other individuals who were in handcuffs, there's something so insidious and aloof about Joel Guy that is so scary. And I can only imagine, with me having that type of observation of him for 15 or 20 minutes, think about what that did to the jury. Yeah, I know that he is, dressed in a suit and tie, but if you look at him for any short period of time, he just looks as if he is emotionally distanced from everything that he did, and also hearing about it all over again, just reminding himself of what he did to his parents, and almost sort of displaying as if, there is just absolutely no regard, no remorse, just this obtuse attitude. And so that's a lot for jurors, because these are supposed to be reasonable people that sit on these juries that have that are well-minded individuals who wouldn't, dare think of doing something like this. So it's very weighty for folk who don't come into contact with this type of scenario on a consistent basis, to just have to process exactly what they've heard.
That's incredible information. So someone like yourself who deals with criminals all the time, pick this one gentleman out as someone who was just incredibly nefarious, and just his whole energy was horrible. So I can imagine a jury looking at him, what he feels, what they felt just looking at this guy. That's incredibly interesting. All right, Leslie Ricard Chambers, please stick by. We have a lot more to discuss right now. We're going to take a quick break, and you'll hear from the family members of both the defendant and the victims in this case just ahead. So please stay with us here on Court TV. I don't know about you guys, but looking at that video, of course, it's heart-wrenching, but I'm also looking at Joel Guy Jr., and I'm saying to myself, his whole posture, everything about him seems to be mocking them. I mean, he almost seems empty, and I want to bring back in our guest, Leslie Ricard Chambers, a former prosecutor and trial attorney down in Louisiana. And I want to go back because you had a connection with her, correct? I mean, with him. You actually saw him. I want to go back. I want you to take me through that, how that came about and what your impressions were again. I'm just fascinating.
I'll be honest with you. It was the most eerie experience in my job as a prosecutor that I've ever had. And this was just an extradition hearing, okay? This wasn't me having a PE. This wasn't me having a motion to suppress. This was Joel Guy coming into my courtroom along with 20 other inmates. And he is the one who stood out in the corner of my eye. It was almost as if there was an energy in the courtroom that I have never experienced before. And it was so frightening. And it felt uncertain, I guess. And I'll tell you why I say that. You know, as I learned who he was, who he actually was, you know, his face had been plastered all over our local media. We had some news folk in the courtroom that day. And, you know, so I was familiar with the facts. But it's crazy because when you walked in, you could feel exactly what you saw in that courtroom. And so, I'll tell you this too, it makes you think about, it makes you a little
I got to take a break. I want to get right back into this. I want to give you all the time that you need, but I am coming up against a hard break. So let me take a quick break. We're bringing you again live coverage of the guilty verdict in Tennessee versus Joel Guy Jr. We'll take you live to the courthouse after a quick break, and we'll get back and get more information about this actual sighting of Joel Guy Jr. down in Louisiana. So stay with us. Hello and welcome back to Court TV Live, your front row seat to justice. I'm Michael Ayala. The jury in Knoxville, Tennessee returned for their second day of deliberation before quickly returning a guilty verdict for defendant Joel Michael Guy Jr. Now, throughout the trial, the 32-year-old sat by passively as the state presented an abundance of evidence, including gruesome details of the murder of both of his parents. Lisa and Joel Guy Sr. were casualties of what the state claimed was Joel's plot to profit from their hefty life insurance policy. And the jury ultimately found that evidence sufficient to find him guilty of all charges this morning, and the judge pronounced his sentence.
Joel Michael Guy and docket number 110145, after being tried by a jury of peers, the first-degree premeditated murder of Joel Michael Guy, the court now sentenced you to life in prison in the Tennessee Department of Corrections. Count number 2, after being found guilty by a jury of peers of the first-degree premeditated murder of Lisa Guy, I now enter sentence of life in prison in the Tennessee Department of Corrections. Count number 3 is the first-degree felony murder during the perpetration of first-degree premeditated murder of Lisa Guy. The court now sentences you to life in prison in that count to merge into count number 2. Count number 4 is first-degree felony murder during the perpetration of theft of Joel Guy Sr. The court sentences you to life in prison in Tennessee Department of Corrections. That will merge into count number 1. Count number 5, the first-degree felony murder during the perpetration of theft of Lisa Guy. The court sentences you to life in prison. That will merge with count number 2. That will be the court sentence.
All right, joining us live now from outside the courthouse in Knoxville, Tennessee, is Court TV legal correspondent Chanley Painter. Also with me, Leslie Ricard Chambers. She's a trial attorney and a former prosecutor, as well as Ian Friedman, a criminal defense attorney. Thank you all for being with me this afternoon. I truly appreciate it. Now, let me go back to you, Leslie. I want to just continue our conversation because I find it fascinating. It's really given us a glimpse as to just who this guy is. So let me let you continue. You were talking about he was with a group of criminals who came into your courtroom, but yet he was the one that grabbed your attention. Tell me about it.
He did, and excuse me, his energy was just so concerning. And you know, one of the things that bothered me after that extradition hearing was the fact that I knew that he was an LSU student. That LSU is literally maybe 5 miles down the road from the courthouse that I prosecuted in. My girls attend the lab school on LSU's campus, and it just sent an instant sense of fear in me, the fact that they have been in such a close proximity with somebody who has the potential to do something like this, killing their parents, and not just killing them, but dismembering them and making sure that their bodies are unrecognizable. You know, this is something that, you know, when I was in that courtroom, I knew that he had killed his parents. I just didn't know all of the circumstances. And so when he walked in there, like I said before, there was an instant energy that he sort of brought with him. And that anyone in that courtroom, whether you were a defendant, whether you were a prosecutor or a defense attorney or anyone sitting in that gallery, you sort of knew that something different about him or that there was something different about him. Not that the other, you know, defendants who were in chains, you know, were not criminals, but there was something very scary about him and the energy that he brought into that courtroom.
Oh, just incredible. Chanley, let me go to you and ask you if you felt any of that. I mean, you've been in the same room with him for the last 4 or 5 days. Did you feel any of that?
You know, interesting question, because today, this morning, the verdict being read and then the victim impact statements, it was during the victim impact statements when I looked over to him for anything. I mean, these are his family members. He grew up with these sisters. And there was no reaction, not even a break in his facial expression that I could tell. And it really made me a little sick to my stomach to think about what everything has been convicted of. The culmination of the past 4 or 5 days of evidence inside that courtroom. Yeah, it's difficult to sit in the same room even with him. I don't know how the family had the courage to stand up and go to the podium and say anything that they did say without even looking at him and just keeping it professional and full of grace. I don't know that I could have done that, Michael, and I'm not even related to them or the family. So definitely a different defendant than we've seen on court TV. It's been interesting to watch him enter the courtroom. He almost has like a pep in his step. He's carrying a bunch of files when he comes in and out of the courtroom. He's integral in his defense. It's just been very interesting.
Oh, unbelievable. Now, criminal defense attorney Ian Friedman, you have a tremendous amount of experience. You come across a defendant like this who radiates, I mean, from what I'm hearing, radiates pure evil. I mean, how do you deal with that?
Yeah, thankfully we don't see them that often, but when you do, you certainly remember them. I remember every one of them over the course of my career. And, you know, like Chanley and Leslie said, may have stood out. I mean, the writing was on the wall here. I think the prosecutor used the right terminology with the book of premeditation and just kind of following that script. This was an incredibly difficult case to defend. Joel knew it. And, you know, when you reach that moment when the verdict is being read and the family's getting up there, true colors are shown. This is who he is. It takes a special sort of person to be able to do what he did. And, you know, unfortunately, we like to believe that there's not pure evil out there. Again, there's not a lot, but there are some. And Joel Guy, Jr. appears to fit in that small list.
Yeah, you know, I want to go into the jury a little bit because Chanley mentioned to us earlier that when the jury was delivering their verdict, one of the jurors, or at least one of the jurors, was looking over at the family, shaking their head. Now, one of the issues brought up early on by the defense was that by placing the jury in a different position, sort of in the gallery as opposed to in the jury box, the face shields, the masks, all those things amounted to perhaps a due process violation for their client. I'm wondering how you guys feel about that. Let me go first to you, Leslie. Do you think there's a case there to be made that all of these different changes might have had an effect on the rights of the defendant for a fair trial? And I only point to it because, again, the jury was sitting in the same place, just opposite of the family. And I wonder if there was perhaps a kinship created that might not have been created had they been sitting in the jury well, and maybe that's some of what the defense was talking about.
Maybe so, but look, defense attorneys, and no offense to the other defense attorney on the panel today, but listen, they've got to raise any objection that they can to show that their client was prejudiced in any regard, and they've got to do that because this case and the circumstances surrounding this case, the evidence is so strong that it is sort of a case that they've lost already, I guess, once they come in there. I mean, I'm pretty sure that these are excellent attorneys. It sounds like that they did some really good pretrial work. They did the best that they could under the circumstances. But, I mean, I don't think that the concerns that they raised are weighty enough to suggest that that Joel Jr. didn't get a fair trial.
Yeah, it is certainly a high bar. Ian Friedman, let me go to you. Let's take a different scenario, because I agree. Nothing was going to change the outcome of this case, but let's take a case that's a little closer, that could go either way, and you have the same situation. Could that be an issue?
Yeah, so this is kind of the biggest issue right now for the defense bar across the country. The concerns are, as you mentioned, Michael, the wearing of masks. How does one judge the credibility if it's a witness wearing a mask, or if it's the jurors during the jury selection process? Now we're talking about the nonverbal communications that the defense lawyers are looking at when trying to select the jurors, the positioning of the jurors to the family and elsewhere. There are a number of issues, and just before you even get there, going forward with trials during this age of COVID right now, who are the jurors that are going to want to come in? What we're seeing a lot of the courtrooms doing are automatically dismissing people who are saying they'd be concerned about coming into those courtrooms. So you're not getting necessarily a representative jury. You're getting jurors that either are not scared to go in there or who are willing to deal with those fears because they're looking at this as so important. But we see, just from the small number of trials that have started, we're losing a good number of jurors right from the beginning, whether it's by a questionnaire or by preliminary questions. And then, so as a defense lawyer, I ask myself, well, those who are in there, if you come in with all the plexiglass and everyone's in masks and the deputies and everyone else, isn't that telling them it's a dangerous place to be? And really, are they going to spend the amount of time necessary to decide something with the most important of, or as the most important of their affairs, like they would any other time, or are they going to want to just get out of there? So is this the right time to be trying cases? Now, in this case here, unfortunately, I agree with Leslie that, yes, the evidence is overwhelming on it. And so is this the right case to decide whether or not there was prejudice or a due process violation? Probably not. And that's why, Michael, I wish that this issue had been decided kind of on the less egregious cases so that we weren't simply saying, yeah, there might have been a violation, but look how serious the crime was. It's definitely a consideration. Defense lawyers do not want to go forward right now, plain and simple.
That's interesting, and it's an issue that will certainly come up on appeal in this case. Chanley, let me go back to you because you were in the courtroom. Just generally, your overall impressions of how all the precautions worked out, if any, there were any impact on the trial. I also know you spoke to some people about the jury pool and how that was selected. So tell us about that.
Yeah, great question, Michael. We were here last Thursday when the jury was being selected. In fact, nobody was allowed inside the courtroom. They brought in a couple of panels of 25 prospective jurors, and in the media, we had to watch a video feed to listen to the questioning. And I have to say, a lot of the jurors, prospective jurors, expressed concerns about COVID-19 restrictions and conditions. And of course, the defense was asking in voir dire those questions. Are you uncomfortable? Will this affect your ability? And many of them did say yes. So it did narrow down a lot of those potential jurors because of COVID-19 concerns during the jury selection process. And then when the trial started, I noticed they were extra careful. As you can see in the courtroom, there's numbers for the spots for each of the jurors to sit spread out in the jury box, in the gallery. Everyone had to wear a mask, the plexiglass up there at the judge's bench. And I noticed the judge also making sure that he would ask jurors, especially those back on the 6th or 7th row in the gallery, if they could see everything and if they could hear everything. He did that multiple times during the day as testimony unfolded to make sure that they weren't disadvantaged because maybe they weren't as close to the witnesses or the defendant during the trial. So a lot of precautions, and the judge felt comfortable with that scenario and overruled any defense objections concerning it.
Yeah, there's a fine balance there. You want to protect the rights of the defendant, but also protect the health of those in the courtroom. All right, guys, please stand by. We'll have more of the emotional impact and victim statements made today when we return, so please stay with us.